So thanks everyone for joining this morning. Ken, can you talk to a little bit about what was the impetus for this discussion? And I know that
Sure.
we've dealt with it in our cases, in varying degrees, and it would be nice just to have an informal sharing about how we've dealt with some of these issues. But I was just curious, Ken, what precipitated this discussion for you or why you were interested in
Sure.
pursuing it?
Sure. A recent case that I just started working on the last 2, 3 weeks um, has multiple LLCs, which either own property or are a vehicle for construction of homes. And we're talking, I think, roughly six different LLCs with different configurations of partners. And it just made me realize that, you know, if we were to sort of group the cases that we get in, some of them are cases. I remember a case years ago with someone who had, I think, a combination automobile repair business in Mount Kisco and used cars that they were selling. So it just struck me as interesting that we come across these different kinds of businesses in our practices. In this particular situation, my most recent case, it actually started as a mediation, and there was a an initial report prepared on valuation of these business interests by someone actually involved with collaborative and mediation. And I received the report yesterday and was reading through it. It's just an initial report. And, it made me realize as well that in this situation, because these are LLCs created for really a particular purpose, um, that the business valuations themselves aren't really that significant because it's
Mm.
more of a pass-through kind of situation, and the entity is only useful for a period of time, and then they move on, end the use of that entity and move on to a new entity for a new project in construction of homes or apartment buildings, versus sort of the typical either mom and pop situation or the situation where a client has an interest in a hedge fund. So, you know, the issue does come up in different contexts, and, none of them are necessarily plain vanilla.
One thing, Ken, I was thinking, that's why it seems to me that it may be important for, and before an evaluation is done and paid for, that it may be important kind of at the start. I don't know if y'all do this to like really think through, like just exactly how you stated it. Is this something that needs to be valued, or is this something that is sort of a different animal, if you will,
Right.
and should be handled a different way? Or just to
Yeah.
kind of put some creative thinking on when you're looking at it and what impact it's going to have on the case. So how
Yeah.
much of
No,
it do you need to
that's an
really
excellent
get
point,
into?
Sally. Yeah. And, I think the problem is that I don't know how other people do it or feel about it, but I know that with cases, when I get started, I don't know what I don't know. And there's a certain degree of security in having a financial professional take this task and pull the information together and provide a report. Because for me, it often takes a few weeks or months to wrap my brain around the issues in a particular case. and the business is usually only part of it. You know, you're dealing with other issues, custody, access,
Mhm.
support, the emotional issues that you're trying to help the client deal with and or get past. So I think your point is a very good one. And this situation really, I think, supports that. But on the other hand, it's hard because you just don't know enough early on, at least as the attorney, you don't know enough early on. And you're just sort of trying to plow through all of the issues in the case and get a better sense of things.
Yeah. I mean, I had a case recently. It was a collaboration where I'm just looking at the agreement now. It was like a lot of business interests that were in different LLCs and different interests that each party held, but it was primarily the husband who was my client, who was um, the investor, you know, and the wife was like listed on some of on some of these LLCs. And it really took a lot of like analysis, a lot of just really understanding from my guy, you know, and for him, it's like that's all he does. So he has like a different language and just trying to
Right.
understand it and really spending the time and really, you know, going through each one. And the wife actually had a pretty good handle on it. She was really a partner and an active one in many of them and had a lot of information, which was good. But trying to figure out when they have different, like for the carry, you know, the capital calls and, you know, and all of this, how to structure that. And we were going to put everything into like a funnel trust account, you know, put them all in like a trust. And then we had to speak to like their trust and estates council to try to figure out that. And we ended up just holding them and just having a lot of detail on, you know, in the agreement. It was very detailed and having their tax, you know, their accountant, their, you know, their business person, like a lot of consults with all the different players just to kind of weigh in on the best way of handling it. And I think that was just for us, it was a really good, prudent approach, just to bring everyone in, all the players, and just try to understand what the best option would be. And at the end, they didn't do this trust account. We just, you know, held it in a way that, in the original way that it was titled and had provisions in the agreement, how capital calls will be handled, how when the distributions happened, how it would be, and even a separate account with how the capital calls would be funded. There was a complexity, but it was actually the most simple way of handling it. But it definitely was something that was it was like a big education for me too, because it was a lot of the structure of these things. There's like such a complexity and the tax implications on all of this too. So to put all those provisions, but working with the financial neutral was helpful, but it wasn't enough. We needed to bring in other people to help us.
Yeah. And also too, you know, if you need income from those entities, if you will, that are going to impact child support and spousal
Yeah.
support,
Yeah.
that comes into, and I was wondering in this case, was income
Yeah,
an issue for that,
it wasn't actually, which made it
Yeah, I was
easier.
thinking in that
That
case it
was
might not
easier.
be.
It was definitely easier, but my guy definitely, you know, was thinking, oh God, they had enough really to probably retire, but he was still working and he did not want to continue to work necessarily. So having that analysis on terms of like, you know, what would happen, you know, because he was like 60, he's 62, so he may be retiring maybe in like 5 years. But if there was any retirement sooner or what happens upon retirement, so the income from those assets had to be kind of configured as well, just to see.
Hmm.
So that analysis was important, but it wasn't needed. But I can see how that would have been even more complicated
Yeah.
to deal with that.
Yeah. Yeah. I'm
Yeah.
sorry, Carmen.
So I'm just sort of curious when there's in terms of the structure. So if it's a divorce and there are still capital calls. So the LLC is still being funded or whatever it is that the assets that this LLC is purchasing or supporting are still being funded. In terms of the equitable distribution, how is it and there has to be an end date. There has to be a termination
Yeah.
date. So
Yeah.
how do the capital calls impact the termination rate, or how do the capital calls impact the amount that was distributed to the parties, or was it a progressive distribution?
It was a progressive distribution, and it was, and some of them had definitely different call dates that they knew that this was, some termination dates, and others that were just an ongoing. So, but there was also just an incredible amount of trust between these two clients too, which I think helped in a tremendous way. I mean, because that whole concept of having it in this trust was one way to kind of eliminate that interaction between the two. And they didn't want that. They felt really confident, or they had a trust in each other to handle it, themselves directly.
Well, and there's also another interesting issue in terms of what you're describing, and in my case with the LLCs, if you're dividing up these business interests, the whole concept of the double dip, because in my case in particular, the wife is seeking spousal support. And to the extent that she's getting her share of the value of the businesses, there's that element of these businesses are generating income for the husband that people are then looking at as a source of spousal support. And, I don't know about the rest of you, but I don't handle this kind of case every day. And it might be one or two of these cases a year or 2 years. And so it's almost like you have to get up to speed on the issues every time. And then, when does a financial professional get brought in? When do you have the chance to talk to that person and ask these questions and get, some evaluation on the double dip, and how significant is the double dip? And, in my case, the other part of it, if I were to characterize the issues, the business interests are maybe 25% of the significant issues in the case. Spousal support is probably going to be another 25% in terms of difficulty of resolution. And then in this long-term marriage, 1996, I just noticed, I was emailing on it, and the wife's birthday, the day, is the same as the date they got married. You know how sometimes in cases you see dates that, there's some kind of correlation? I don't think I've had this one many times. But, in terms of addressing these issues, one of the big issues in the case, probably the biggest, is my client's inheritance of funds, either life insurance or gifts from father and aunt, which were given, some of which were given a long time ago, some of which were more recent. And then, what we refer to as commingling issues, really converting separate property to marital property. And so it's like none of these issues come up in a void. We've got to deal with them along with so many other issues. And it's a challenge.
Yeah.
Figuring out that interplay and advising the client.
Yeah, and I think that the financial person needs to be part, and that's just my opinion. Of course, I'm a financial person, but at the beginning,
Yeah.
because I think that they need to, think it through, and it takes time. And if you settle something and then the financial person comes in later and goes, oh, maybe this or that, then that messes up what's already been settled, and then there's rework. So
Yeah, for sure. Carmen, did you want to share? And then Lily, and then Adam, and then I'll go after with my hand.
Oh, So I was wondering, Melissa and Ken, in your experience, are the issues, do they tend to be, I was sort of struck, Ken, when you said about getting up to speed with all of these issues. And I can imagine with all of the tax changes and all of just the regulatory changes, the legal perspective has to be quite complex. And then in addition, there's the full financial perspective. So I was wondering which one you felt was more challenging, or was really more, was there some sort of interplay between the tax issues and the tax ramifications and the domestic relations law, whether that was more of a challenge?
Yeah, no, it's a great question, Carmen. Um, we're dealing with the client, we're dealing with the other attorney, we have a series of issues. I don't, I think, the most challenging part is balancing all of it and also being willing to reach out for help because, I mean, I've been doing it. I was admitted February of 1985. So officially I'm coming up on 41 years, but it's still a challenge. It's like, I don't have a template that I can go to and say, okay, this is this case, and I had this case 2 years ago, and this is exactly how I could do it. You know, I think it's the balance, and I think it's getting help from a financial person each time to better understand the issues because they're never identical. I don't know that I could say one is harder than the other, Carmen. I think it's just making sure you're identifying the issues. And with the business valuations, probably recognizing, as I think Sally has said and Lily would probably say, um, is getting the financial person in as soon as possible.
Yeah. Yeah. Yeah, for
Thank-
sure. Yeah, and it's also just tapping into as to what, let's hear from the clients what their concept of equitable is. And in this particular case that it was a true collaboration with a full team, and and the onset was with the financial person was onboarded first, really, to, we knew the complexity of what we were dealing with. That being said, at the end, it was really the voice of the clients and kind of going through and saying, hey, this is what we feel is to be fair and equal. We understand everything, and we got all the legal and we got all the financial. And at the end, this is what we feel. And what was really interesting was that each investment that, had to be divided up, as well as there was also support issues. And the support we dealt with separately or at the same time, that was part of it. It was part of like this package almost. And what we decided with the support was that the earned employment income was to be shared net equally. They did this whole, that was the agreement that they had, and that the other investments, which were tremendous, that they both had, and retirement and so forth, was just not factored in, that just the employment income was going to be, we figured out the net after tax. We did that analysis, but that was a standalone and that was fair and equitable for them. Then when we did the analysis with the businesses, we actually looked at each business and said, okay, well, moving forward, my guy was going to have more of an active role in the investment and contributions to building it. So some investments were going to be divided differently. Some of them were going to be like 60-40, 70-30. A lot of them, though, were 50-50 because a lot of them were during the marriage, that they were both kind of active or felt that that was equitable. But that's how we went through it. And I felt at the end, it was just, I think, satisfying for both that they were both heard. We unpacked like every investment saying like, what is that? Like, oh yeah, you're more into that than me, or this is more speculative. This is more like it was both risk tolerance as well as contributions and what was meaningful. And I felt that at the end, that kind of resulted in a result that they both felt really good about. I don't know if that answered your question, Carmen, or not.
Yeah, I think that's all really, it's really it's a given, no matter how many of these
Yeah,
cases we do, how many of them we may think they're cookie cutter, because none of them are cookie cutter, right? Because
yeah,
they're all people. But it's very helpful to have a setting like this where we can all just be honest with each other and just say, you know what? I don't know the
yeah.
entire body of law. I don't know how ERISA interacts with the DRL, or even if ERISA is relevant, what the most recent I mean, so I really appreciate the candor and the frankness.
Yeah. And if anyone's interested, I mean, this was a really, I mean, I could ask my counterpart, but I can redact, some of those provisions if anyone was interested to see it, because it was really something that was reviewed by the financial person, their accountant, their business advisor, and it's working. I mean, it's working. And if you're
I would
interested,
love that.
Yeah.
I would love that.
Also, I think it's interesting too that the support got separated out, that you were able, because usually I tend to think of those as more integrated, but that's an interesting concept that you were able to keep that as a separate. And I think, Melissa, your point of listening to the client, that's like, I mean, obviously, and that I think could possibly make things simpler for us
yeah,
if that comes out in the beginning as well, to kind of, because you need
yeah.
to see what's going to make them, they're the ones that know best anyway. So,
Right. And legally, my guy gave far more. The amount of support was beyond guidelines. I mean, and he knew that. And I had to kind of go through, and he was okay with that. But it was a very, he really wanted to make his wife really comfortable. It was really, really important to him. And but I had to, on my end, kind of go through the guidelines and say, listen, you understand that it's capped at a certain amount. And then afterwards, there's a whole bunch of factors and equal distribution. There is interplay. I mean, we're talking like, it was about like $10 million that they were each getting. And it was still support that she was receiving. Probably, I think it came to like maybe $700,000 a year,
Yep.
so it was generous, but that was important. And also supporting kids beyond 21. We're talking like having like wedding funds, like graduate school to fund an apartment in this, like housing for kids that, to get them through till 26. And that was just really important to them, but we need to kind of they knew that they were going beyond, but for them, it was just the right thing to do. Lily and then Adam.
You know what strikes me about this whole situation is how attentive we are to listening to the clients and how sustainable their agreements will be because they've been fully engaged. And it's really remarkable because now I'm on a few litigated cases and this does not happen. Let me just say this kind of situation of where you go through meticulously the education and informative piece of each one of the financial issues and how they interrelate never happens in a litigated case. In my experience, they're just told sort of what to do. They have a person standing in front of them that takes their position. And I think this is so remarkable about collaborative divorce. It is so remarkable that these clients can walk away saying, I know everything in this agreement and I was there for that and present. And it's whether they're doing it knowingly and in sync with one another as your clients were, Melissa, or I have clients that have the same kind of complicated financials and they're not in sync at all. They're high conflict. It doesn't really matter because the informative piece of it is what gets them to the finish line. They feel as if they understand that they made a right decision or a fully informed decision. That's this beauty of this whole process, I find.
Well, it's also, in terms of the clients, and Sally, I mean, the neutrals, I think, probably see this often. I'm the second attorney in this litigated case that I mentioned. My client is the one who knows everything about the businesses and the finances. And as a result, everything is being asked of him. And of course, he feels like he's being critiqued or questioned. And so it's a tough balance to try and push him to cooperate and agree on some issues. And at the same time, not alienate him because he feels like he's giving in on things and but he's the one with all the information.
Mhm.
He's the one who's got to give. And so, on the other hand, in this particular case, the wife feels disadvantaged because she doesn't know everything. And that now she's engaged in the process, she's empowered, which is fine. But it's a tough dynamic. And the other attorney is trying to get her client as much information as possible. They actually spent either $50,000 or $60,000 on doing a tracing.
Oh, my word.
And,
Wow.
and I asked if I could get that tracing and was told no. And my client feels like he can do some of it, but the attorney before me never really educated the client on separate property. My client was going on an incorrect assumption concerning separate property, and it's very possible that millions of dollars of separate property were converted to marital property.
Mhm.
And again, I'm trying to bring the client along slowly, but it's tough. And, that's part of the dynamic of these cases, especially with the businesses where one person is the primary person in the business and the other person, it's that whole control thing. You know, is the husband controlling or has he just done everything he needed to do? And on the wife's side, of course, she feels that he's controlling. And so it's an interesting dynamic, an interesting set of issues.
For sure.
Yeah, and it's interesting too, Ken, in that the where the emotions get into it and how that can sway the how it's going to go if she feels he's controlling, but I just and that just messes up the whole thing
Right.
sometimes as to how you know objectively evaluate this thing because you've got these two different emotions around the topic of the businesses.
Sure.
Yeah.
And I've worked well with the attorney on the other side, and we, in other cases, have been able to do agreements, partial agreements, and gradually narrow the remaining issues to the most difficult ones. And on the one hand, the client says that he wants to get the case settled. On the other hand, um, when I posed certain partial settlements to him, he feels like he's conceding something without getting something back. It's sort of the typical situation. So it's it'll be interesting to see 3 months, 4 months from now. It's actually scheduled for trial in April,
Oh, Lordy.
which is the other demanding component of it. So
Yeah. Adam, did you want to share? You've been so patient.
Well, I'm listening, and this is a really interesting conversation, Ken. Melissa, thanks for sharing. I think Ken just got to the point that I was wondering in my mind, which is really in some ways about process, right? Because I'm hearing like, income, and then there are all these, things are happening, including the possibility of a trial down the road. At the same time, you're also ramping yourself up on the case, right? And I was just curious, as to what extent there was a stop the clock agreement, or there were partial agreements or interim agreements, because I do think even in principle, right? Like you want to, if you can, maybe put something aside so that you can focus your energies on, something else. And I don't know. This is something I've had, same thing, Ken, kind of like good experience with, but also tension with. People don't necessarily want, to pay me to write something else, or, or they want to see how it all plays out. Meanwhile, you're still trying to figure out what is the whole field. And at the same time, maybe you want to, not tie a bow around, but at least in principle, try and memorialize what can be agreed to in the moment. And I was just wondering, like, to what extent that cropped up in the case.
Yeah, no, it's a very good observation. The mediator, the parties entered into a stop the clock agreement. It's hard to tell the significance of that in this case. There were at least my client perceived that there were other agreements in the mediation, but there was no actual written agreement memorializing these two understandings. So in the litigation, that means that they're not agreed to. And it would have been helpful, and I realize, what is it? Hindsight is 2020. I realize it's easy to say a year later that if this could have been done, but I also have an appreciation for how difficult a case like this would be to handle in mediation. Where the wife doesn't have a confidence level, the husband really knows all the relevant information. In this case, there are separate and marital property issues. But if a mediator was sitting with these people, and my client, who, is very financially sophisticated, says that something's separate, does he really understand what that means? And how do you, as a mediator, pick up on that? And so, it's definitely nuanced when you have these kinds of assets in a mediation and a collaborative, but in a mediation where you're sitting in the room with these two people and you're trying to, just like I said, I'm trying to sort of get my head around all the issues here. But I'm just dealing with my client. In the mediation, you're dealing with both people. And I just have so much respect for being able to do that well, because it's got to be hard, and it's got to be hard to still maintain your neutrality, not make judgments about the people. But yes, there was a stop the clock, but it would have been better for my client, at least, if the mediator had prepared agreements on these two issues that are unresolved now.
And there's no way to do a collaborative for those two issues without.
It gets into the whole overarching issue of accounting, or my client being able to prove what is separate property. And so it's tough. It would have been a more practical resolution in the mediation, but now it's just part of the whole argument about what's marital and what's separate. And in a way, it added to the confusion as to what my client did based on what he thought was resolved. So at this point, the case is probably only going to settle a few weeks before trial, when everyone is putting tens of thousands of dollars of time into the case to prepare the thousands of pages of documents that are going to have to go into notebooks and all of that insanity. So
Yeah.
It's tough.
Yeah. Well, when I struggle in mediation, when I'm working on like something like on a small business and the clients are both like adamant, like, no, we don't want it to be valued. It's not, and they have like a position, they're coming in and it's like they think that's fair and equitable, but you're sitting there and knowing, hey, this is a business that should be that could be valued. It's an asset and you're educating them. And so what I'd like to do is just say, listen, just have a consult at least. Some financial people do consults that maybe don't charge, or it's a middle where it's just like a small fee or just something. But what I struggle with is mandating that. Like I never like to say like you have to do something, but I strongly advise. And I'm just curious of what other people have done with that. And some people have like consulted with and then found out maybe it's going to cost this much to do it, or maybe it's not worth, maybe it's not even a business to be evaluated to get that a third party to give that expert, input. But what I struggle with was when they don't even want to do that and how you approach it.
If you can think of what is the purpose, what is it we're trying to do with this business? And sort of really kind of come at it from that point of view. Because sometimes if it's really just to get the income, maybe you don't need evaluation. Maybe you just need more of a forensic looking at the books and records of the business, you know. So I think that's important to get in mind to start as to what are we trying to do with this business?
Right. Yeah, because it's like for income, for support purposes, as an asset. But then if they don't even want to do that, and you want them to have agency and understanding, and I guess then it's like the CY, as a mediator, like a CYA letter, you do that, but it's still something I really struggle with. It's still something that I'm thinking like, should I just say like I can't work with you unless you do this and get this analysis? And I haven't gotten to that point, but I'm getting there because I heard of wasn't my case, it was somebody else of a colleague, and it was just not, it was a mediation that went into a litigation, and they were called in, the consulting counsel were brought in and deposed, because there was this business that wasn't valued, that was actually waived. About 3 months after the agreement was executed, the business was sold for like good gobs of money. And they were going and they were and they were challenging, they were not yet divorced, they had still the agreement, challenging the agreement and what was known and all of that. And they did not get any kind of analysis of that business during the mediation. And that, after I heard that and what my colleague was going through with, it was just horrible. And it was a very limited, it was like, she said that she consulted, it was a very, like, the wife really, her client really wanted to get it done. She might have had like a 3-hour retainer. It didn't go beyond that. She actually even had emails that said, this is what I really recommend this. And they still called her in. And it was just a nightmare. About $10,000 of legal fees that she had to incur just to represent. And it was just a nightmare. And so she's sharing with me language, I'm sharing with her language. You just have to protect yourself in different capacities, whether you're the consulting counsel or the mediator, when you have businesses and analysis that's not done. And it's
So
scary.
Melissa, I'm sorry for interrupting, and I get it, like that's mediation no number one, but that please share, because I can't think of a single one of my cases where, and I put it in my summaries that you're waiving getting any sort of valuation. I mean, like none of my clients, for financial reasons, want to do a valuation. So, and that's my greatest nightmare, is to get sued.
Yeah, well, I'm still working on it because like my colleague is like, it was devastating to her.
Of
Devastating.
course.
So I'm just, I'm giving her some space and we're going to work on it. But when we do it, I'm going to share it, what we've developed. But it was just horrible. What a horrible situation. And it was in another state too. They reached the agreement in New York and then they filed in Connecticut. And it was all this it was just a nightmare.
I kind of join Carmen here. There have been times when I've really put my foot down and said, I'm not going to continue for one more second until you
Mhm.
do X.
Yeah.
Get a reviewing attorney or something like that. Because I could smell like something felt very imbalanced, but somebody just wanted something done. I'm thinking of like one or two particular cases. But I have to tell you, and I'll say it to this group, I'm very sorry that I did because then I lost the client. They were angry with me. They were like, Adam's not getting it done. I was sitting there like screaming, like, like, please, like call Sally, like call Carmen. Like,
Right.
Yeah.
I'm like on my hands and knees. Like I'm
Right.
saying this because I want the agreement to stand. Like I want this to be,
Right.
not the situation that you're describing, Melissa, or like whatever. And I could kind of see it down the road. And in hindsight, I kind of wish I had just drafted a monster waiver that basically, says something like, I gave you every opportunity. We gave you this. I suggested this. You rejected net worth statements, like whatever, like, whatever the language would, many of us are familiar with, where people say, Adam, we don't want to spend any more time, money. How much is a valuation going to cost us? How much is not a tracing, but how much is this going to cost us? I don't know. It's, to Ken's point, it's like bringing the clients along, whether you're reviewing attorney or the collaborative or the mediator, and they don't want to come along anymore. They just want what they
Mhm.
want. And even if I'm saying something like I want to do this to protect both of you and your business and all of that, I get a ton of pushback, and I feel like you just have to say, okay, I'll, sign here where it says I advise you otherwise, but you waive the evaluation or doing evaluation. I don't know.
Yeah.
So, Adam, my 2 cents on that, and I hear you because I've lost clients, but I sleep at night.
Yeah.
And there is something about my moral compass, right?
That's right.
I
That's
hear
right.
you, Carmen.
When I hit when I and I say that to you because I know I know your moral compass. And I know that's precisely why you're
It's
insisting.
changing, Carmen. My moral compass is shifting. Like
Well,
I hear you, Carmen. Thank you.
Yeah, but sleeping at night is I value that highly.
I do too.
Yeah.
I do too. And you know what? A CYA letter, that's not going to keep you out of litigation,
True.
right?
You're right.
And then God forbid you didn't draft that CYA letter precisely, which by the way, none of us do because I'm not a litigator. So,
Right.
you know,
Yeah.
Yeah. And also too, after listening to all this from you all, sometimes I have a tendency to think maybe the business doesn't really have to be evaluated, but business evaluators will tell me, oh, it should. It's just sometimes I've seen business valuations that really were not that thorough. So I get concerned that the client spent all this money and they didn't really get what they needed. But after listening to you all, I really now understand why the business valuation is so important, maybe even if it's not as thorough as I think it should be, or even
Right.
if I think
Right.
that it's not completely needed. So I really appreciate getting that getting that feeling from you all. So understanding. So thank you for sharing all this.
Right. Right. Yeah, and I'm just reminded after that case happened that I was helping supporting my colleague. I was the consulting counsel on a mediation where it was a business and it was somebody who had like no idea about not financially very sophisticated, wanted to get this done, incredibly guilty because I think she, had an affair, ended the marriage, felt horrible about it and felt as though get whatever she deserves it. She deserves whatever bad settlement's going to happen here. So I reviewed an agreement that was done in the mediation process and just not even an agreement, terms. It has not been reduced to a writing yet. It was the mediator, and it was the same mediator actually who was the consulting counsel. She was actually wanted to have consulting counsel on the onset because of that experience that she had. And it was really so they both had consulting counsel and I was for the wife who wasn't the business owner. And I'm looking at these terms, and the terms were, it just wasn't equitable. I mean, anyone on it just was, and she's like, I deserve this. I was such a bad, I'm just horrible. And I'm like, well, legally, you can seek more. What you're asking for, punitive of doing what you did, doesn't rise to the level of equally dividing property in the way that's being proposed here. So we bought in a neutral. He didn't want to bring in a financial person. I suggested that she work with a financial advisor. So we connected with a financial advisor for herself, because the husband didn't want for the team, but was okay for her to manage, to help her manage her finances moving forward, and just to help evaluate any proposals. And after the meeting, we had a series of meetings, and then suggestions on how better to look at the business and the income from the business, because the terms were it just wasn't an equitable result. And I had a real worry about my client being self-supporting, and being able to manage, so we worked something out, and I had, comments, and all of the comments were rejected by and the other guy, he had the husband did have consulting counsel, and all but maybe, a few were rejected and saying, no, this is what I'm offering. And basically they haven't reduced it to a writing yet. It wasn't drafted yet, but I had to kind of say, okay, I can't continue to work with, you're going I don't want my name to be listed in the agreement, and I can't control that. But I put it on the email. My name should not be put. I have not reviewed any agreement. I know the other consulting counsel who I believe is drafting, and I have a good relationship, that I just need to check in on that. But that's also a worry when you've consulted, you don't see the final agreement, and how to protect yourself. That keeps me up also. And I don't know how to address that other than sending a letter or doing an email, but it's still out there.
Send the letter, send it FedEx, have it documented that you sent the letter and that it was received.
Yeah.
Absolutely. I mean, that's what I've done, because
Yeah.
I've sent the emails saying my name better not be in that. I'm not signing off on that stipulate, like forget it. And then I follow up. And in Melissa, I had one client who refused to accept FedEx delivery 3 times.
Holy moly. Wow. So
But again, like I kept record of all, because FedEx sends me note, so I kept a record of everything. And then I think what I did was I emailed her again, and finally, like the 4th time, I got the receipt.
Wow. Okay. Yeah.
And I always, if I'm in that kind of situation with notice, I would always send it by regular mail and overnight, if you think that's appropriate, because there's a presumption of receipt with regular mail.
Oh, okay.
So
So, Ken, I'm sorry for interrupting, but how do you prove that you sent it through regular mail?
Or you could do that priority mail, and then you get a tracking and a receipt, and you get the proof of delivery. You put it in those priority envelopes. So that's what I do that a lot to the IRS, and then I'm able to see that it got there. I do that all the time to the IRS, actually. So
Yeah.
Carmen,
but those work nicely, because you get an email, you can track it, and you get the receipt. It just keep all that together.
In addition to that, Carmen, we do affidavits of service all the time in cases.
Of course.
So we'll do like an
Of course.
affirmation just confirming that it was sent both ways.
Of course. Mm-hmm.
We have it, and God forbid something happens. Can you find all these things 3 years or 5 years later? But if it's more than 3 years, at least you're past the malpractice statute of limitations. But
That's a great suggestion.
Yeah.
Love that. Thank you.
Could
Yeah.
it be like an affirmation of service? Like, does it have to be?
Yes. Yeah. Now I'm just used to saying affidavit of
Yeah,
service.
okay.
The whole affirmation thing is great.
Yeah.
I had an interesting experience on Monday. I mentioned this to Melissa earlier in the week. I ended up in court up in Orange County for 4 hours on a new case. I was the second attorney in, and the client, it was a short marriage, no kids, people in their 50s, 60s. But the husband had all of these separate property LLCs. He owns like 4 or 5 properties in Westchester and Orange County, and one up in the Catskills. And the client claimed that she had done many things with regard to these LLCs. And I ended up filing a limited purpose appearance, which I've started doing more often. And you can do this, I think it's under CPLR section 320 subdivision D, where in litigation you can file a limited purpose appearance. And I put that I was only retained for settlement. And I had done that in another case. And there had been settlement proposals exchanged, and she was represented by someone for a period, but then ended up appearing personally pro se because she couldn't get along with her attorney. And we ended up settling the case on Monday. First appearance. I'd only been involved for a week. But there is that, with what we're talking about, there's that a little bit of concern. The client was very appreciative. We ended up at a number. She got almost $250,000 in a situation where they were married in 2017, no kids, and he started a divorce action in 2021 and withdrew it, but they essentially were not husband and wife as of 2020 or 2021. But, it's just so interesting, the things that we have to deal with and the situations that we're confronted with. And just, to Sally's point, people want to get things done. They want to work out settlements. And we're here to facilitate that. But, you're still left wondering many times, what's going to come of the case. And is this woman going to get buyer's remorse? And luckily, we were on the court record, and the judge was very clear, and a lot of questions and a lot of points being made. And so I do have the protection of a transcript, but it's tough. What we do is tough. And I was up last night. I actually got an email at 8 o'clock about a client who had a car accident and is in like Vassar Brothers Hospital now. And we were trying to get documents signed for a real estate closing this week. And she's been denied seeing her children except on a supervised basis. And I'm just hoping that there's no alcohol involved in the accident. But it's always something. And so luckily there's Wordle.
Luckily, that's right. And spelling bee and Scrabble.
Right.
And for me, Bravo. I love that network. Really is a great.
And your talk shows.
And my talk shows, I went to The View this week, Kelly Clarkson. It was good. I'll be working all weekend, but it was a nice break for me. I enjoyed it. And I got like some good giveaways, so I'm happy. One of them was like a shiatsu foot massager and a back massager.
Oh, wow.
And this like LED face mask that gets rid of all my wrinkles. I'm like psyched. And then SpongeBob movie tickets. So I'm gonna go see SpongeBob.
I love
And
SpongeBob.
Mark Hamill is one of I saw him, and he's one of the character actors. And I met the actual SpongeBob person. It's amazing.
Wow. That's like a life memory.
You should wear all of that, Melissa, during like your Zoom mediations or like whatever. Just have like
What a great idea, Adam. Like
have the
all of
button
your
up.
giveaways, wear them all at once.
Just
Oh, what a
like,
great
when
idea.
they show up, just be like, hi,
Or put them in the
this is
background.
Bob. It's like,
Take down your diplomas.
tell me about your business valuation.
Then, All righty. Well, thank you guys. Happy
Bye,
happy
guys.
Thank you,
holidays.
everyone.
Happy and
Good
healthy,
seeing you.
everybody.
Take
Take
care.
care.
Bye-bye.
Happy holidays.
Bye-bye.